This is Elizabeth Townsend. It's August 2nd, 2001, and this is an interview with Mary Grier. And we're going to begin. We're going to begin at the beginning, well, at the sort of law beginning. With sort of just a standard question of sort of what made you go to law school, and was it what you expected when you got there?
Good questions. What made me go to law school was I actually had started out on a pre-med track. I thought I wanted to be a psychiatrist because I was really interested in what makes people tick and why we do the things we do. And I had done well in science, and I got to college, and by strange coincidence, I started doing some public speaking in high school, competitive debate, primarily because I was so shy in school that when I had to stand up and talk in class, I would cry and get embarrassed, and it was very traumatic. And so my parents recognized that that was not a good thing for my long-term success, and I kind of got put in a role where I was forced to go out and debate and talk, and I liked it once I got over the fear of it all. And so I got to college, and I was taking microbiology and chemistry, but what I was spending all my time and energy on was debate and public speaking, and finally a little voice in my head said, you know, is this really what you want to do? Do you really, and the other voice was, do you really want to be around sick people all of your life? And the answer to those questions was no. So I got into competitive debate at the college level, and without a clue really as to what it would lead me to career-wise, and this may be a common theme, you'll hear more from me later on that, but I got to be a junior and started thinking about what am I going to do with my life, and the people that I knew were either going on to grad school to teach or they were going to law school. And so teaching didn't really seem to me like something, especially teaching speech and debate wasn't really my preference. I thought, well, law school will be a lot like debating. It'll be fun. There'll be this kind of objective clash of ideas, and you do it in the framework of rules, and it would be, you could achieve good things. And so that's what led me to law school.
And well,
it was not like what I expected it to be. It is not at all really like debate, although the skills that you learn doing public speaking and debate are helpful. It's really just a small part of what it really is to practice law. So I had my law school experience, I think, was a shock. I did well enough academically, but I really didn't feel happy about what I was doing. I didn't, you know, you go in your first semester and they throw these case books at you, and you start reading cases, and you're saying, why am I reading these cases? And you know, I felt like it took a long time for the light bulb to go on, and for me to say, oh, okay, you have to figure out what you're getting out of these cases, and if they do the work for you, it doesn't really, you don't get the same thing out of it. And I was kind of like that all through law school. There were parts of it that I liked, but most of it I thought was not very rewarding. And then when I got out into practice, there were parts of it I liked a great deal, but I was still, I think, struggling to bring the reality of practice in line with what I had expected. It took a number of years for me to do that.
Yeah, and we'll talk more about that in just a second. I want to ask you a couple of questions before we go on. So, as a child, you were shy, and you did with the public speaking. Did you feel like I was shy, very, very shy child, and I'm just curious if you felt like could you be shy? Did it help you being shy in public, and were you still shy in private, or did it sort of get you over the shyness? And sort of for other sort of shy people who haven't had debate experiences, sort of what do you do when you're in law school now and you don't even want to you don't want to speak in class or any of those things? How do you deal with that?
I think it's hard. I think that particularly if you're interested in litigation, you have to get over that in some way, and I think the best way to do it is to inure yourself to it, to do it to the point that you no longer have 20 minutes of quaking. Maybe it's only a minute of quaking before you actually launch into what you're saying. I think there's a lot of research about lawyers and who becomes lawyers that indicates that many of them are really introverted people. And maybe that's another word for shy, people who are not really public about themselves, who aren't really interested in being in the spotlight. They're more analytical. And there's a place for people like that in the practice of law, I think. I don't think being able to stand up in class and sound brilliant is necessarily a good indicator of how good a lawyer you're eventually going to be. And I think that people who have, for example, good listening skills, good interviewing skills, a lot of empathy, who like puzzles, who like to put things together, who like to figure things out, who like mysteries, who like to solve. There's a lot of attributes that go into practicing law, and speaking in front of bunches of people is one of them, and it's only one of them, and it's really only important for a certain segment. So.
And do you have any practical advice when you get up to speak that would make you feel a little more comfortable, or accept the shaking, or accept the tears, you know?
Well, by coincidence, I attended a seminar earlier this year that I thought was really terrific. I wish that it had been offered in law school when for people who are interested in litigation practice or appellate practice. It was taught by a person who's not a lawyer, he's an actor, and he basically he took a group of lawyers, everything from a couple years out of law school with maybe one trial under their belt to 40 years out of law school, retired judges, and got them to focus on the physical aspects of public speaking. And as part of his presentation, it was very hands-on, very much, get up and just do 5 minutes of an opening, and then we'll focus on what you're doing physically. He wouldn't warn you, but that's what he did. And you would get people who were obviously very uncomfortable and nervous and had these distracting habits. And in the process of helping people to be more effective with their body language and their voice and their eye contact and persuasion, all the physical aspects of public speaking, he made a point, which is that the number one fear that people have kind of universally is a fear of speaking in public and speaking to groups. And that part of overcoming that fear is to acknowledge that it exists and to prepare yourself for it. And he recommended, for example, before you have to go in and start a trial, and where you have to voir dire the jury, and you kind of launch yourself in, and it's awkward, and things haven't really settled into a pace. He recommended that you go into the courtroom and you know what the physical layout is going to be. And that on the way to your trial, whether you do it at your office or your home or in your car, you practice just talking out loud and hearing yourself talk and feeling yourself talk, getting your breathing into a normal, a calmer, more relaxed. Because what happens when you get nervous is everything kind of tightens up and your voice tightens up, and you feel really self-conscious. So he prescribed some habits that actors use really before they go on and perform, and it sensitizes you to this acute feeling of awkwardness that everybody's staring at you and you're the only one doing all the talking, and it's so weird. And so I think that kind of advice, getting people to kind of sit back. I tell witnesses this because you're a witness and you're afraid and you're listening, and when you sit back and you breathe, if you do yoga, if you do yoga breathing, those kinds of things, relax you to the point where it really takes a lot of fear to get you back to where you're so tight that you just can't function. So there are a lot of little tricks like that. I'm sure others have different ones, but it can be done.
What about how much do you when you're experienced and you're into trial versus when you're very, very beginning? How much do you practice all the things you're going to say, and does that make you, did you do like moot court or things like that? I mean, do you encourage that, or sort of, I don't know, how do you feel prepared for the speaking part as opposed to the analytic part?
Well, I think that I did moot court and I did the Jenks competition, and I practiced for those a lot more than you ever get to practice in real life. Or maybe I never allowed myself the luxury of practicing. But what happens when you're getting ready for trial or a motion, at least what happens to me, is I get so, it's another thing about lawyers, many of them are left brain perfectionist fanatics, and you have this illusion that you can, if you just work a little harder, you can control everything. So I'm going to read all those cases again, and I'm going to know what every question is they can possibly ask me. So you're so focused on the substance of your presentation and the substance of the arguments, and what are they going to ask me, and how am I going to answer this one, and how does it all fit together, that polishing it up and making it sound rhetorically beautiful is something that I have a very hard time doing. I usually practice things at least once or twice, but not anywhere near as much as you would like if you were giving a very polished and eloquent, you know, if you were going to be a Daniel Webster and really make it sound wonderful. Fortunately, one of the events I did when I was doing public speaking was extemporaneous speaking, and what I find is that I don't work well if I've tried to memorize something. And so I really, and in fact, the more I have written out, the more elaborate it's written out, the harder it is for me to do it effectively. So I try to organize my thoughts and my arguments, whatever it is that I'm about to say, into kind of a short, concise, few words for each point that will remind me of the basics of what I'm going to say. And then I just try to extemporize and try to make it more conversational than eloquent.
And did you come, was that out of figuring, I mean, does each person have to figure out what's best for them in that, or do you find that a lot of attorneys, as they get more experienced, find that works better, or maybe it's just time that they don't have, you know, you can't write out everything?
Well, let me answer that this way. The very first deposition I ever had to take was a custodian of records deposition, and I didn't know what the heck a custodian of records deposition was or what you had to do to take it. You know, I was a little intimidated. I had not been to a deposition, and one of the older lawyers in the firm kindly gave me a transcript of one that he had done, and he said, you know, these are just the basic questions you ask. And but I had every one of those things written out to the letter. You know, I read them off, I'm sure. I checked them off every point. After you've done more, you know, the more you do it, the more you already know what you do. And so the crutches yourself to kind of get over being afraid or missing something or not knowing enough about it get to be smaller and smaller. There are lawyers who still write out every question that they think they're going to ask, and who are computerized and have everything very well thought out. But I think that as you get more experience, you tend to get less reliant on that and be more willing to go with the flow. And what that frees you to do in a courtroom setting, in an appellate argument setting, is to not be so stuck with what you thought of coming in that you can't adjust to something that you didn't think of that may be the key to the whole case. So you have to keep your brain engaged enough to respond to what somebody's saying. I mean, I've seen lawyers, particularly young lawyers, go into court and they'll ask questions that seem like they haven't listened to the answer that their own witness gave them, because it just, you know, they didn't hear the answer, so they're asking it again, or they're getting to the next point and the witness has already told you what you're asking for. And it's, you know, you're sympathetic to that, but you realize that that's one of the problems when you write everything out and you get too dependent on crutches. So as you get more experience, you trust yourself to be able to think and to be able to talk and think under pressure, and it just gets easier.
What about trying to remember every little thing about every little case, and you're afraid that somehow you're not, I mean, do you just try to memorize it or have notes, or that sort of fear of, like, you know, I mean, you know, that you're going to somehow forget the name of something, or it's going to be the wrong case, and you're going to put, that whole panic of, like, I know everything, but I'm going to suddenly forget all of it. Sort of all of those things.
I think the more that you prepare, the better you're going to know it, and the less likely you are to forget. I think you have to, at least for me, what happens to me when I get too obsessive is that it's almost like a car engine that goes into vapor lock, you know, you just can't get past it. So I think you have to, if you're preparing a case, and my experience is primarily civil experience, so I think it can be very different for people who go in and it's the burglary of the day or the assault of the day, and they do hundreds of trials a year that take a half day or less. In the civil side, when you actually really try something, it's usually after a lot of time spent taking depositions, interviewing witnesses, poring over exhibits, organizing your thoughts, checking your proof against what you have to prove and all of that. So it's really hard to forget the details that are important, because if you've prepared the case well, you're living with it. It's like, would you forget your sister's name? Probably not. But you might have a moment when my sister, and you'd forget, you wouldn't be able to spit it out because you were afraid or distracted or something. And so you have to know that people tolerate that they don't expect absolute perfection and universal knowledge of 100% of the details, and give yourself permission to have to check your notes, be prepared, have things ready, but try to rely on your own ability to. It's important because you work the case. And what I do is I tend to write out the major points I want to bring out from each witness, and sometimes if I think it's going to be difficult, or if it's an impeachment question in particular, I'll write out the exact wording that I want to use, or if it's laying foundation for a difficult exhibit, and I check it off. But I try to do it in a short and one or two word format as I can, so that I'm free to think, and instead of it being so focused on remembering every single detail, I can know that I've already thought about it and just go back and double check before I let it go.
What if you say something and you realize it's not right? What do you do?
Well, it depends on the situation.
I just think of the things like you think. That's another fear of, like, I'll say this is what a case and it wasn't that case, or I've got it all sort of jumbled, or like, do you just stop and say, what do you do in that situation?
I think if you're arguing to a court, for example, which is very different than arguing to a jury, it's important that you get the case right. It's possible that the judge is going to remember the name of the case and the fact that you got it wrong. So if you realize you made a mistake, you just correct it. You say, I realize I referenced the Cohen case, it's really the Smith case. And move on and not make a big deal about it. I think a lot has to do with the effect of your mistake on the whole situation. So if it's just incidental, that's one thing. I wouldn't worry about it too much, and I probably wouldn't spend a lot of time correcting it. If it's going to lead somebody to make a mistake, or it's going to make you look like you're lying about something, or you're trying to deceive the court, then it's very important to correct it. And you just have to trust that judges are humans. They had to practice as lawyers, most of them, once, and most of them are pretty charitable towards, particularly towards new lawyers. They don't like having their time wasted any more than anybody else does, but they're not going to crucify you because you make a mistake or because you falter a little bit or do something like that. They're pretty empathetic.
What about a mistake in front of a jury? Or when you're afraid that I don't know what kind of mistake that would be, but I'm just, again, sort of the fear factor of if you say something or ask a question that you realize you shouldn't have started to ask, or any of those sorts of things where you start to second guess what you're doing. What do you do? I'm not sure if that's a good question or not, but sort of what you worry about when you're speaking in front of a jury, and what can go wrong. How do you deal with that kind of stuff?
Well, I think all the sorts of things, the forgetting, the misspeaking, mispronouncing a word or a name, referring to your opponent as your client. I mean, there's a lot of ways that, a lot of mistakes that people make when they're nervous. And I think that the principal concern you should have in front of a jury is that they're continually assessing you and your client and your case, and they're looking for things that don't jive, that, you know, that are inconsistent with your view of things. And so what you want to do at all costs is preserve your, what in public speech we would call your ethical appeal, your ethos. The tendency of the jury to trust you and to believe that you're telling them the truth is going to be eroded if you don't tell them the truth. So if you stumble or you make a mistake, and it's a mistake, you know, and it's just because you're nervous, far better to have a way of saying, excuse me, I meant Mrs. Jones, or, you know, whatever it is, so that the jury knows, and they know you're nervous, and they know it's a big deal, and that's consistent with the truth kind of that they're going to see, and hopefully you'll get smoother as things go along. And what they're not tolerant of is people who lie to them, or people who deceive them, or try to cover things up. And so that would be my concern, would be making sure that you're communicating effectively kind of the truth of your side of things, and that you're not, that it's not viewed as some kind of a Freudian slip, that you really know that, you know, the person who's really guilty here is Mr. Jones, and, oh, I mean Mrs. Smith, you know, that kind of thing could be pretty bad. So you try not to make those mistakes, but you try to preserve your integrity with the jury.
Before we get to the topics that we still haven't gotten there yet, but this is really good stuff. Okay, you had said something about when you were early, like high school, that you liked what makes people tick. And I thought maybe we could talk about that a little bit more, but in terms of the different players, in terms of law, like what makes clients tick, I mean,
Sure.
What makes juries tick, what makes judge tick, that kind of stuff. Like, is there sort of things you're looking for, or what, I don't know, just sort of what your thoughts are about, like, what that means. And that may be too hard of a question, and we can sort of break it down in a different way. But
well, I think here again, there's a difference between litigation practice and transactional practice, because in transactional practice, what you're focused on for the most part, not exclusively, but for the most part, is what are the problems that are going to come up? What has to happen for this deal to come about? How can I provide for what needs to be provided for? And then there is an element of psychology, and how do I sell it to the other side? How do I get from them what I need? There's kind of a bargaining understanding of people in that sense. In dealing with judges and appellate courts and juries, I think it's more that when you understand how those people think, and what is likely to persuade them, you can target your argument or your presentation to what is likely to be effective in getting your point across. And I think that there are some, you know, I kind of put myself in this category. There are some lawyers who do better in appellate argument, for example, than they do in a jury trial, because it's easier for them to understand how judges think. You know, what is a judge looking for? Are they going to be persuaded by this argument or that argument? Judges think a lot more like I do than the average juror does, and so it's less of a leap to figure that out. When you're dealing with jurors, but it's fascinating. I mean, it's really interesting stuff. In your voir dire, you're trying to figure out something about the person's background so that you can make assumptions about how they're likely to think and what's likely to persuade them. And the funniest thing is when you go through that process and you think you've asked good questions and you've ferreted out their you know, experiences that are going to make them prejudiced or receptive or whatever. And then they go and they deliberate and they come back with a verdict, and you talk to them afterwards and you find out which jurors voted which way and why. I just have to laugh, because I have never been on the money. And so assumptions, what I find is that the assumptions you make about people based on incomplete information are likely as not going to lead you into erroneous thinking about the way they view the world and what's going to be persuasive to them. And people that you stereotype in the process of doing voir dire and selecting a jury may be exceptions to the rule. And so clever lawyers and jury consultants have come up with a lot of intricate ways to try to figure out how a juror is likely to think or see an issue. And some of them are doing very well. The average client can't afford a jury consultant for the case, you know, a $20,000, $30,000, $40,000 personal injury case. You can't afford to do a little mock trial and all the things that would get you better information. So you're having to use your best judgment and what you've been able to pick up about people in life and figure out how these people are likely to see your particular situation.
A jury is pretty just much, even with all of the selection and the still kind of a hodgepodge, sort of anybody's guess kind of system that you can't, I mean, I don't know, I mean, like, so what do you do then if you know what I mean? Like,
you know, I think it's an interesting philosophical question. The jury system, I know there are people who come out on both sides of the argument. I've heard very cogent argument for the proposition that jurors are pretty much incapable of making good use of expert testimony. They just aren't going to pay attention to it. They're not familiar enough with the underpinnings of it to make good judgments. They tend to be snowed by people who are slick, and yet on the other side, argument for the fact that jurors collectively have a way of picking up inconsistencies and faults and, you know, overweening personalities and those sorts of things, and collectively they come up with a pretty good judgment. I think eventually we'll probably get to a point where, and in fact I think this is happening a lot in the real world, clients with difficult issues and lots of money at stake are less likely to be willing to trust their fate on a particular issue to a jury, and they're either going to mediate it, they're going to arbitrate it, they're going to try to settle it, or they'll try it to a judge. I think where jurors tend to do better is in criminal cases, where you're asking people to kind of weigh and sift through often circumstantial evidence and the cumulative effect of things, and, you know, to use their guts. They're a lot better at using their guts when it comes to human motivation and, you know, kind of the grist of the criminal trial. And in tort cases that involve personal injuries, I think too that jurors are an important factor, and that there's the ability to kind of try to evaluate how best to compensate somebody for an injury to the person is something that I think jurors may be better at than judges.
in terms of judges, how much do you, kind of back to your speech and debate days too, how much are you performing or working for a particular judge, and how much is it your own sort of what you do? Do you know what I mean? Like, sort of how much are you playing to a particular audience versus like, this is the show I put on no matter who's there? And does that mix change depending on the situation, or I guess depending on if you're a big place where you know the judges or not, or small place?
I think a lot depends on what you know about the judge, and if you're in trial a lot, which is not the case for most people, then you tend to get to see a judge more than once. Or if you're in a specialty court like the bankruptcy court, where there's only 2 or 3 judges and you see them all the time, you very definitely would tailor your presentation to what you know about that judge, because you know that certain arguments are not going to carry any weight, and that certain habits of speech or stylistic approaches are going to be offensive to them, and you try to avoid it. But if you're, as so often happens, you're just going into one of the 80 divisions of the Superior Court in Maricopa County, And maybe there's a newly appointed judge that has been assigned to your case, and you know that this person was with a firm or with an agency, but that's about all you know about them. I think you try to present your case as effectively as you can, without regard to who the judge is.
What about fancy language? Like when you're in law school, some people are really good at like saying all the fancy words of the law words and the law lingo, and every sentence they have has like thousands of those words. And then other people like struggle just to be able to say, you know, plaintiff, and they sort of skirt around them. And should you just your thoughts about sort of, I mean, obviously it's different if it's between a jury and a judge, sort of the way the audience you're speaking to, but sort of, is it your own style, or should you feel comfortable, or should you be using big words because they're more impressive to people, or I don't know.
I think one of the myths that law schools used to perpetrate, and I don't know that they still do, but they did it through law review and the approach to legal writing, was that it's better somehow to use legalese and to construct these page-long contorted sentences that all, you know, Herman Melville style or something. Everything that I've heard and seen in practice is the people who are the most effective at persuasion are the ones that use not fancy words, but evocative words that conjure up a connotation or an image that helps the listener to see their point. And so using legalese, and what they'll tell you in appellate advocacy courses is immediately define your term, so that instead of talking about appellant and appellee, you're talking about, you know, the bread company and the employee, or so that the judges reading the brief are not going to ever be confused about who's who or what's what. They tell you, write simply and directly, eliminate all excess adjectives and adverbs, and avoid repetition and avoid legalese if you can, because it's not very effective at persuading people about or getting them to understand what the real issue is. The other thing that I'll just throw is some of the best, was certainly eye-opening for me, because I came out of law school thinking that, you know, we have these ritualistic ways of doing things, and I should be copying what they're doing in these cases, because that's the way you act like a lawyer and you sound like a lawyer. And I thought that everything kind of went according to the rules. There are these rules as to how judges decide cases. That's what the law is. It's this big set of rules that all fits together, and you just look through the rules and you figure out what the right answer is. And I remember sitting in a presentation where a couple of appellate court judges were talking, and they basically said, what you need to do in appellate argument is convince me why at the gut level I should vote for your position, why I should decide in your client's favor. I can make the law do pretty much anything I want. I can contort it, you know, and they weren't quite that crude, but trust me, they can work with legal principles and procedural arguments and issues in such a way that they come out to the result that they think is the just result. But what they're really trying to do is the right thing. They're trying to do justice, and often that isn't necessarily something that just requires them to apply a rule of law. It requires them to understand and who's wrong and who's getting the shaft, and is it right that they're getting the shaft, that kind of thing. And once that sinks in, it makes it a lot easier to write and speak more effectively.
Any other thoughts before we move on from this topic? No?
Nope.
This is great stuff. Okay, achieving balance. Give us the answer to achieving balance, or some thoughts at least.
Well, I'm going to throw out things that I thought were wise that other people have said.
Good.
And one of them is, you can have it all, but you can't have it all at the same time. And I think that there's a perception that law, practice, and family are kind of an either-or proposition, that you can't, or that if you try to handle both, that you're inevitably going to be short shrifting one or the other. And I don't think that's necessarily true. I think that it's when you try to have everything, you try to have the most pressure filled and financially rewarding legal practice, and have children, and also have a social life, and also, get to read. There are some things that you give up if you want to practice law and have children. And when your children are small, you pretty much don't have a social life if you want to spend any time with them. You give up maybe a lot of money in order to have them well cared for in your home or in a child care setting that you're comfortable with. You give up maybe having the best job, the most demanding job, being a partner. And it isn't necessarily so that you have to give these things up, but you have to be looking at what's the most important thing to you. And you have to, what I thought was really difficult, what took me a long time to figure out, was that you express your true values by what you spend your time on and what you spend your attention on. And if you're spending 95% of your attention on work and 5% of your attention on your family, then what you're telling them is, I value my work a lot more than I value my family. And so I think that in order to have it all at some point in your career, you probably have to make some hard choices about trade-offs and be willing to be flexible and to re-examine those choices as you go on, and your circumstances change as your children get older, or different circumstances affect everybody. The other thing that I remember that really struck me was when I was living in California, and my husband and I were both working full-time, and we had a 2-year-old and a 4-year-old, and I was standing in line at the grocery store, and I was getting really irritated about how long it was taking. And I'm thinking, I get paid, it's not that I get paid this, I can charge my clients $160 or $170 an hour. Lord knows it's probably $200 or $250 an hour now. Don't these people know my time is valuable? And you kind of get this sense of your own importance that's really blown out of proportion. And it's tied to this feeling that, at least I had this feeling. I remember when I started practicing, I couldn't believe anybody would pay me for my advice. I didn't know anything. I came out of law school, and you really feel like you do not know, you have no judgment. What you have is a bunch of legal rules and all this stuff that you've crammed in your head, but you really don't know how things work, and you aren't a very wise person, at least I wasn't. And now there's people that want to pay you more money than you've ever seen for your advice, and it's kind of hard to believe. Well, as you adjust your thinking and you go, well, yeah, because you have to be able to feel that you're worth what you're charging if you're going to live with yourself and practice law. You start, yeah, my time really is worth it, because this other person would pay me $200 an hour to work on their problem. So you get this sense that you're more important than other people because you're paid better, and that the best thing you can do with your time is to work because you're going to be paid for it. And so kind of in that context, there was an article published in one of the California bar journals entitled The $250 Sunset. And it was basically the point that there are things that you can't put a price tag on. And for the most part, they're the things that make you the human being that has a family, interests apart from work. And that when you mix those things up, it causes this funny calculus that distorts everything, and you just have to be conscious of the fact that your thinking can get skewed by things that really aren't a good measure of what's important and what you're worth. So, you learn that you always have things to do when you're waiting in lines, and you try to be patient with people whose lives are just as important as yours and whose time is just as valuable as yours, even if they're not paid like it is. So.
All right, so you've got a 2-year-old and a 4-year-old, and you work and your husband works. How does that work? How does the day work?
Well, I'll describe a day for you.
Okay.
you have to have a spouse, and I have to say right up front that I know there are single parents who work and care for children and handle all the household details, and I admire them all others in this world, because I don't think I could have done that. What we did in our family was to kind of divide up the day. So, and I think this is pretty common. My husband would drop the kids off at their daycare in the morning, and I would pick them up. And when things got really busy, what would happen? I can remember when we were still living in Tucson, my husband was in graduate school. He went back to school to get a master's in electrical engineering, and he had his thesis due, and he had, he was having to come in at the lab, and so we would get snippy over who got to go back to work at 2 in the morning to get their stuff done, or who got to, well, you worked at 4 yesterday, it's my turn to get up at 4 with stuff I have to do. And you get this totally bizarre competition for, not for personal pleasure or anything, just for time to kind of deal with the overload that accumulates when you're busy. And you have to really be conscious of the need to build in a safety valve, to take it, not be too proud to take advantage of help if your family offers it, to be willing to pay for things that it's either your time or your money sometimes.
Like what?
Well, for us, we ended up paying to have someone supervise our children until this year, and my kids this year are 14 and almost 16, and they are very happy that because they were so embarrassed to have a babysitter when they were in high school. But for us, what allowed us to be comfortable with the way things were at home was and we still had to divide the day. My husband had to be there in the morning, and I had to be there at night to fix dinner, but I knew there was somebody there watching my children and handling their after-school needs and everything, and it's expensive. It's like $10 an hour or more to have somebody come in and provide that service, but it's really worth it if it means that instead of constantly rushing around trying to do everything yourself, you have a little breathing room, and you have somebody that you can call and say, hey, would you take the ground beef out of the freezer and defrost it, and things that have to get done that you would be responsible for doing, but that because you have somebody there. For some people, it's hiring a house cleaner. I know for a lot of people, that's the one thing they really hate. And it's so nice to not come into a pit at the end of the day and have you walk in and then your house is magically clean. I'm trying to think of other things. Laundry, sending your clothes out to the cleaners, even though they could be washed. Some people will don't wash any laundry. The people I've known who've done this have mostly been men, so I'm not sure that there are a lot of women who do it, but they take everything to the underwear, shirts, you name it. They have everything dropped off, and it comes back neatly, and they hang it up. There are services now that you can hire somebody to wait at your house for the refrigerator repair guy, and maybe it costs money, but it means you don't have to race across town, be frustrated all day, cancel your appointments, do things that really make your life a lot more stressful.
What about when things go wrong, when kids get hurt or sick, or meetings run longer, or all those sort of, and the question really is sort of employers, like, are they reasonable, or do you feel like you're always hiding what's happening in your life so that they don't think of less of you, or I mean, all those, I don't know if those are another fear, other sort of fears.
I think it's like anything else, it varies. I currently work in the Attorney General's office, and one of the reasons when I came back to Arizona that I decided to do that was that I had endured the stresses of trying to juggle the demand for general business, billing and collecting hours, getting your work done, and handling all the family details. And it's got to come out somewhere, and it comes out of you. And you learn to live on 4 hours of sleep a night, and you feel after a while that you're on this little treadmill, that you're just like a little rat in a cage, and you're running and running and running, and you just want to get off because life loses its meaning. And I say that although I really enjoyed my legal practice both in Arizona and in California, but my children were in, first and third grade, or second and fourth grade when we moved back to Phoenix. And I knew there were going to be things that I just couldn't do if I were in a really demanding law practice where you're expected to work nights and weekends. And so there are many very well qualified people working in government, because government does not expect you to spend 80 hours a week. Government does not expect you to bill a moment of your time. Government gives you vacation, and you really get to use the vacation because government expects you to. That's one of the trade-offs. They pay you less, but they understand that your time on the job is limited, that it's not an unlimited commitment. Now I'm losing the thread of what you asked me.
No, soccer games, kids getting sick.
Oh, I think in our office, they're very flexible about. I mean, they understand that there are some times, and you understand, there's sometimes you're in trial, you're going to be maybe working 80 hours a week for the 3 weeks you're in trial. But in return, when your child has a play or a soccer game or a doctor's appointment, you can take leave and you can go to it, and nobody judges you for that, nobody docks you for it. I would like to say that that's also the case in private practice, but I think the reality is that in private practice you're always being compared with your co-associates, or if you're a partner, with the other partners in the firm. And those who are not distracted from the important business of serving the clients by things like sick kids are in the calculus of evaluating people. I don't think that most employers give many points for being a good mother or a good parent. And so they may tolerate it, and if you're performing well, they'll hope that you get over it. But and they'll know that in the long run, children grow up, and if you're in a firm and you have a solid association, you'll be able to kick in the same level of performance that other people do. But I know a number of women who have consciously negotiated a less than full-time position, that they actually work more than full-time, but because they can say, I'm only here 3/4 time, they look like a pretty good deal compared with the rest of the people that they're working with.
Interesting. What about men? Is it still just a woman's issue? Is it just women who are facing this? Or are there, well, of course, it's a soapbox. No, I was going to say, should it be a man's issue as well? but do you see any changes where men are concerned by these problems, or is it still balancing as women balancing?
I think statistically that it's more often women who are doing it, but I think there's a much increased sensitivity on the part of men, and a much increased, from when I started working, tendency of men to insist that they participate in taking care of. It's less so for household chores and things, more so for the fun, kid things, but even so, a lot better than it used to be. And again, there are men in our office as well as women, and many of them are parents of school-aged children, and one of the things they value about the job is that they can take time off to do their fair share of child rearing. And there are increasingly more single fathers with custody, of children, and they have to do the same sorts of things that women do when they're juggling. So, and yes, I think they should. The silent question that you really wanted to ask, I really think that that parenting, active parenting, adds a dimension and quality to that men benefit from and are entitled to enjoy just as much as women. And so beyond kids can be a hassle, they can be whiny and fussy and bickering and all those awful things, but they're a tremendous blessing and a tremendous joy. And fathers who don't allow themselves to have the experience of parenting beyond, sweeping it at the end of the day and kissing them goodnight, are really missing out. And I think that male lawyers who allow themselves to do that, ultimately benefit professionally because their perspective is different. It's a little broader than it is if they don't do that, if nothing else. And they can come up with some great analogies that they use in argument or, illustrating a point. And it gives them a bond that they might not otherwise have. It's a more universal bond. And so it's interesting when you hear men, the old stereotype is that men and women get together socially and the men go off and talk about sports and the women go off and talk about kids. I think a lot more often you hear now the men talking about kids. And I think it's a good thing.
Totally. Yes, I'll have to say that in my utopia, those big firms, the men that are running the big firms would be forced into those areas. I mean, as soon as our culture this is my soapbox now, this will get cut out, but usually
that's all right. It feels good to say it anyway.
But it's just like if we could just get a culture that understood that everybody is taking care of the kids, that we wouldn't have these long hours, and we would have it structured so differently. And it seems so frustrating to be at the beginning of another century. We were still dealing with these issues. It's insane. I mean, we'll get there eventually, but I just,
I think in some ways it's getting worse, where email and cell phones, and you can't ever get away from the office.
You can't, I know.
That's true.
It's
bad.
It is not good. Setting limits is harder when you have all those things.
Yeah.
All right, well,
okay.
that was our break.
Well, thanks for letting me pontificate on that.
Okay, we have to talk about what you do, because we haven't gotten to what you do now.
Okay.
Can we talk to you just a little bit more? How are we doing on the battery and the...
No, it's fine. We'll fine. On here.
Okay. So, what do you do? We've heard lots of things. Where do you work, and what do you do every day? What do you...
I work at the Attorney General's office. I'm in the Natural Resources section, and I am principally assigned to work on major litigation for the State Land Department, a little known and underappreciated state agency. And in terms of, you would think major litigation for the state land, but in court all the time, not wrong. I think in the 7 years that I've been in the section, I've had administrative hearings, maybe 4 or 5, a trial on stipulated facts, and a number of appellate cases, but and cases that we were preparing for trial. But I believe that if you're doing your job well, you will settle 95% of your cases, especially if there's anything significant at stake. So being in court a lot is unfortunately not what I do, even though nominally I'm a litigator. Say when they were sick and little, I would sometimes be forced to bring them with me to the office for a short time. I'd had to get something out or had to sign something. And they would say I have the most boring job in the world because all I do is talk on the telephone and type on the computer. And that is probably still, that describes 90% of my days. My days might also include a site investigation where you drive down to a farm in Pinal County to see the site of a potential well contamination, or a field trip to understand how a claimed right-of-way affects a particular piece of property. It's all property-oriented stuff, and so knowing how the property is situated with respect to everything else is pretty important. So there are some, my time might include taking depositions or doing witness interviews, but I'm afraid for the most part there's a lot of research and writing and analysis and giving advice, a lot of meetings, a lot of phone calls asking about things. Could you find the answer to this question? And you drop everything and try to find answers. It's probably doesn't sound exciting in an LA law or a law and order kind of sense, but it's property related issues tend to be real puzzles and tangles of facts and law and history and physical situations, and most of it's pretty interesting.
Have you always been interested in property related questions, or is this something not new, but
Well,
how did you get here? I guess is the question.
the literal truth is I decided where I wanted to work first, and then there were different opportunities available within the agency, and this one fit best with my background and experience. But I had originally been interested in a program at UCLA that they offered a joint doctorate in law and urban planning. And unfortunately, my scores were a few points shy of getting into UCLA, and I was kind of anxious to get started, and I didn't want to wait around on the waiting list and hope that I got in. So I came back to Arizona to go to law school. And I'm glad I did. Many things that happened in my life wouldn't have happened if I'd stayed in California. But when I got out of law school, I began working for a very good local firm, and they had a practice of rotating associates through different types of experiences, which I think is a really good practice. And so I did some litigation, I did some work. I wanted to do litigation, and I kind of got in the commercial litigation track, and then we had a big bankruptcy boom, and the bottom fell out of the market, and properties and banks and savings and loans and everything was in bankruptcy, and I kind of naturally evolved into that type of a practice, which is really a property-oriented practice, but not in the sense that I do now, where I deal with a lot of land use issues, Endangered Species Act questions, water law issues, the gamut of more natural resources law. I didn't really have an opportunity to do that. And I kind of accepted to get out of law school that there were few opportunities. I had to earn a living to pay off my school loans and support myself, and I was pretty pragmatic about what I decided to do after law school, and so I've kind of come around mid-career to something that I would have liked to start out doing, but I didn't think I had a chance to do it, and then it just kind of showed up. So.
That's a really good story, because I think that's really, I don't know, I think that, that you can do what that just because you don't do exactly that you can enjoy doing what you're doing when you get out of law school, but you can also do things that you dreamed of doing, that you can, that there's a sense of, there's all kinds of things to do out there, and just because you don't do it.
That is really true. That's really true. And you aren't stuck. You get this feeling sometimes of being stuck in a track or a rut. And if you're willing to temporarily retrench financially, you can make a shift in amazing ways. When we moved to California, it was because my husband had gone back to school, gotten this double E degree, and couldn't get a job in Tucson. And so we went to California, and I was leaving, having been a partner in a firm here for 10 years almost, and going to a place where I knew absolutely no one. I had no contacts. I had to take the bar exam and all that. And I thought, well, I'll take some time off. I almost got selected as a juror on a first-degree murder case, a capital murder case, but the prosecutor knocked me off, thinking that I was a bleeding heart liberal. Little did he know. So much for stereotypes, too. But I was going crazy at home with 2 little kids all day, and while I was studying for the bar exam, I applied, I just blind sent letters out to some of the local firms offering to do some clerking work. And this firm called me up and said, oh, we'd love to have you do some clerking work. And so I clerked for them until I passed the bar, and then they said, well, gee, we'd like to have you stay and work for us. And then eventually they made me an offer to become a partner, and it was, if I had insisted on making the same income that I had left in Tucson, I don't think that opportunity would have come up for me. It would have been too big of a risk for a small firm to take on an unknown person at a high salary. But because I was confident that once in the door, I would do the work and they would value the work appropriately, I had an opportunity that I wouldn't have dreamed of when I got out of law school. And it was kind of the same thing with the Attorney General's too. I had to be willing to take less money, but eventually I'm in a position of doing something I really like to do. So.
All right, so the question we have, it's a kind of a hard one because we ask people, but it's hard to people.
Right.
Money's a funny thing. How much money do you need lawyers are, you've got this whole gamut. We have public interest people, we've got super expensive lawyer things, and sort of what should students be thinking about in terms of obviously it's choices and where you live and what kind of car you drive and all that, but how are you supposed to think about money? And maybe that's just not even a question that you can answer, but it seems like no one ever, do you know what I mean?
Money is one of those questions that is emotional for married couples fight almost as often about money as they do about children, and basic issues kind of fall into the third and fourth and distant fifth. I think that it's difficult for a law student to know precisely the mix of circumstances that relate to the range of money that's available for practicing law. And so you can go on to the World Wide Web and look at, there's good information out there about what does a partner in a Phoenix firm make, what does an associate in a Phoenix firm make. There's not such good information about small firms and solo practitioners, and people tend to be less focused on those options. But I really think that the basic principle is that there's no such thing as a free lunch. And maybe for a few people, I'd like to believe that cheaters never prosper. And I know that some cheaters do prosper for a long time. And so in general, you get what you pay for. And if you get the big salary, you're paying for that in some way. And the price may be worth it to you. There are people who absolutely adore what they do, and they're being paid incredibly well for it, and they're great at it, and they're comfortable with it, and, God bless them if that's the way it works for them. I'm afraid there are a lot of lawyers get sucked into the trap of working harder than they want to, working more than they want to, taking cases that they would prefer not to take because you get in this cycle of I have to make my overhead and I have to make my salary and I have to make my, I have to support my family, and I think it's sometimes a more vicious cycle for small firms and solos than it is in a partnership arrangement, because you're the only one there is to do the work, and if you don't bring the money in, you don't get a paycheck. That's just the way it works. And I think people feel conflicted about that, and I don't think you can know at age 22 what your going to want your life to be like at age 35. And I think one of the biggest challenges for law students is to try to find out, to position themselves with respect to the long term so that they can end up doing what they like and enjoy and feel rewarded by doing. And I think often you don't know what's out there, and you don't have a clear idea of how you get to what it is you think you want to do. Some people are very clear-sighted. I was fuzzy. I was kind of like, oh, okay, whatever comes along. Yeah, if it's going to pay the rent and it, I know I can do it and I'm pretty reasonably comfortable doing it, I'll do it. I was a lot more take on different things and just try them. Because I didn't have this vision that I was going to, by age 30 I want to be the chief prosecutor, and by age 35 I want to be a judge, and I didn't see it. I couldn't do it. So some people who are attracted to the practice because it's well paid, that's fine. People something beyond money from their practice, I think, have to be willing to kind of reassess continually. As is the balance right? Am I giving good value to my clients and my partners and myself and my family? And you have to kind of keep juggling that mix. And I think the lawyers that are unhappy, the ones that are burned out, are the ones who can't keep the balance and set limits appropriately. Having been there, I can tell you, there are some of us who have a hard time saying no, and so some client will come in and, I'm denied, I know my trial is next week, but, I really need, and you're so good, and I really want you to be my lawyer, and I know, so you work until 3 in the morning to get ready for their emergency, because you're not really good at saying, no, I have no sympathy for you, or no, I won't do it. And you have to learn how to set limits, and money is a factor. If you want to eat well, you gotta work, unless you're independently wealthy or married well.
Do you have any questions you can think of? All right, here's our dorky question. Everyone gets this one. I think Jerry likes it a lot, and I'm afraid if I don't ask her, she'll get mad. Uh-oh. She'll be like, where's that one? Okay. She really does like this thing. She always comments, that's interesting. Your happy moments in law. A happiest moment or happy moment, or sort of what comes to mind, and that can be anything. It can be anything at all.
Well, this is very un-Zen-like, but I think it's difficult to be happy in the moment. So I think you tend to be happiest looking forward to, or looking back on, something that at the time you did it was really stressful and hard and difficult and sweaty and all that stuff. So, because I marvel that I say, well, I like doing trial work. When you get into the actual grinding work of trial work, it can be very stressful, very hostile, a million details that you have to manage, and so you're kind of slogging through the hard stuff in anticipation of the moment when you are going to, win your victory, or you're going to settle the case effectively. And that moment goes by like that, and then you're looking back on that moment and you're saying, oh yeah, that was really great. That said, I think, there have been times, and it's endemic. Lawyers like to tell war stories, and after you've been through, I guess for me, the happiest times have been, you're in battle, and you have a team on your side, and it's your client, and sometimes there'll be more than one lawyer working on the case, and the secretary and the paralegal, and you get this sense of camaraderie And you actually get close to people that you work with, closer to those people than you would in a normal setting, I think. And when you all work together and you come out the other side, and you look back on it and you tell these war stories, and they're awful. I mean, things that happen. Objectively, you would say, what kind of a sick person would want to talk about that again? And yet, you can be the fact that you can look back on it and that you shared this experience with somebody, that they were there and you were there and you know what it was like. And I'm not being very expressive about it, but that's probably the happiest part. When you're actually doing it, it's constantly, for me anyway, it's constantly, I'm worried, even if you're doing a brilliant cross-examination, you're on edge a little bit because it can fall apart with the wrong answer at any time, and you're always trying to listen and think and write and do, and so it's hard to be happy in those moments. But looking back on them, oh yeah, that was a great argument, or oh yeah, that was a great exhibit, that was a great fun, whatever it was. And preparing to do battle is fun.
Oh, that's great. That's a good answer. Anything else before we stop? Any thoughts or things we haven't covered, or which you wish to say that we haven't said? Or?
I guess I would just encourage law students to think to look ahead more and be less. There's kind of this sense I have of people, when people say, and I had it when I was going, oh, I'm a law student, going to law school, yes, I'm going to be a lawyer someday, and you kind of think you know what that means, but you don't really know what it means day to day. And it's kind of this vague thing out there. I'm going to be a lawyer, and I'm going to make a lot of money, or I'm going to save a lot of people. And I think that it would be, while you have the time as a student, and of course you're saying, what time? I'm constantly studying and working and doing that. But it seems like you have more time as a student. As I look back on it, I had a lot more time than I do now. To go out and try to figure out where you want to be. Try to set up your 10-year plan or your 15-year plan. If you're that kind of a person, if you're a goal-oriented person and it's important to you to achieve certain milestones, then, or if that gives you satisfaction, then you should figure out the path to those milestones before you get started. Because once you get started on a path, it's kind of like the reason people throw good money after bad. It's kind of like, oh, I've spent 5 years doing this, it's got to get good sometime, so I'm going to keep doing it. And as soon as I do X, it'll get better. And if it's not what you really want to do, if it's not meeting your basic needs or objectives or your hidden assumptions about what you want to do, there's going to be that sense of discontent about it. I guess the other thing that I would encourage law students to do is to think about some advice that a career counselor gave me at a time when I was not happy doing what I was doing. I felt like I was stressed out, and no amount of money was worth this amount of misery, and it was all about money and other people's money, and it just seemed kind of like too much work and pain for the return. And this counselor said, well, what her experience had taught her was that people need to feel that they are doing good, either in their work or in addition to their work. And for some people, doing good means being a volunteer, and I think for a lot of lawyers it means doing pro bono service. And so you can do good without having to devote your career to being an advocate for the poor. You can advocate for the poor or give the poor advice or represent the poor in court and do the things you need to do to support your family. But if you don't do any of that, if all you do is work to make money, you're not going to be happy. And it's probably better to know that going in. Because I think a lot of people feel that money will make up for everything, and it doesn't. So that's my advice.
That's good advice. I have one question before you do the 10 to 15 year plan. How do you figure out, I mean, can you just talk a little bit more about how you would do that or what that means?
Sure. I think that in my own case, as I look back on it, I was limited in my vision because there were so many things I had just never been exposed to. I was a very young new lawyer, and I had worked in the usual menial jobs, cashiering and working at 7-Eleven and doing that sort of stuff, but I had no experience of the world of business and even how government works. I hadn't been an activist. I had been pretty much a nose to the grindstone kind of work and go to work, go to school, go home. I think I would encourage people to expose themselves to the possibilities of what's out there. Find somebody who's doing different kinds of things as a lawyer, and people are very accommodating if you don't want money from them. So I would say go sit in a courtroom and watch what trial lawyers do and see if that seems like it's incredibly boring or if it seems like it would be fun. Trial lawyers are often great egotists, and they love being admired and respected, and I think that many of them would welcome a student who's trying to figure out, is this something I want to do? They'd take you on a day of a trial lawyer and let you sit in and see what they do. They'd take you to trial with them. You can volunteer to help them prepare a case. There's a lot of ways to find out. Now the litigation stuff is easy. But you can do the same thing with other areas of law. Lawyers are, there's a desire, I think, particularly on the part of lawyers who do things that are very difficult and complicated that most people don't know much about, like tax lawyers, for example. And there's a satisfaction that they get out of sharing what they know and what they do with somebody else. And I would love to think that my spouse wants me to come home at night and tell him about the intricacies of no, he doesn't want to hear it, he's not interested in it. And I think that's true for a lot of things that lawyers do. And so the opportunity to have a law student come to me and say, gee, I'd like to see what you do all day, and because I'm trying to figure out if that's the sort of thing I want to do. I think students would be surprised at how many lawyers would be willing to share their lives and their experience with them, and at what it would show them about the possibilities. So.
That's very good. It's a good ending to a good interview. Thank you so much.
You're welcome.
This was fun.